Everything you see in this video is just a streamlined version of what you can find on CoinMarketCap. Also, it would mean a lot to me if you could think about supporting my channel financially. As a result, I'd be able to keep writing on XRP and other cryptocurrency updates. Having arrived at this stage, let us examine the most current developments influencing the SEC. Someone has asked for details about where XRP stands in the market right now. With each passing day, the stakes in Ripple's ongoing legal dispute with the SEC rise more and higher. The future of Ripple is in jeopardy once again as questions about the reliability of the Howey test arise right now. Regarding the Securities and Exchange Commission's SEC use of the Howey test to Bitcoin assets, Judge Annalisa Torres made a noteworthy point. The court brought this observation to light. President and Chief Legal Officer of Ripple, Stuart Alderoty, made the public announcement. Using the Howey test as a guide, one can ascertain if a certain transaction satisfies the requirements of an investment contract and is thus governed by the securities laws. Because of this, a heated discussion has sprung up surrounding the subject. It was made public knowledge that Judge Torres acknowledged that the Howey examination had failed to achieve its primary goal in relation to her criticisms. It was made clear to everyone. The court discovered several irregularities that were brought to his attention since promoters had provided investors clear promises regarding a well-defined business enterprise. The court was informed of these discrepancies. An explanation for this has recently emerged in light of a decision pertaining to Coinbase. This topic managed to garner a lot of attention, even though Coinbase was winning in many parts of the case. A United States district judge named Catherine has given the Securities and Exchange Commission the go-light to proceed with its case against Coinbase. Concurrently, no supplementary data was submitted. While presenting FILA's perspective, Alder highlighted a text that showed how a crypto environment may be seen from several angles. In addition, he revealed the SEC pronouncement that declared, regardless of motivation, the purchasing of any token represented an investment in this undefined ecosystem. This should be considered since it is consistent with the ruling that Judge Torres handed down in the Ripple C case. She dug deep into the issue and found that the SEC had seriously misunderstood the Howey test's original intent. Over this time period, marketers did not often give investors clear guarantees about a company's future. You should keep in mind the recent change in course, which is getting harder to ignore. Does the SEC have the authority to lodge an appeal over XRP's existence? That the Canadian Supreme Court had already stated their intention to not appeal the decision is a crucial factor to bear in mind. For the time being, everyone is dubious because Nestel Caius asked a query in an XP post. To be more specific, we need an answer to the question of whether the SEC can shift their position in the future and threaten to dispute XRP's categorization as a security. It's probable that Ripple will make some valid points. In response to the user's remarks, Bill Morgan suggests that the SEC may not choose to challenge the classification of XRP and other cryptocurrencies as non-securities. This is a reaction to the remarks made by the user. Another option is for them to take a broader view, saying that while cryptocurrencies themselves aren't securities, any deal including the sale of Bitcoin could be seen as an investment agreement. This would be a different way of looking at things than what was previously said. Even if a cryptocurrency has no intrinsic worth, the act of purchasing and selling it can be viewed as an investment. With respect to this specific issue, it is critical to remember it. The only cryptocurrency recognized by government is currently facing a great deal of difficulty. Experts in the field think this might affect the cryptocurrency's value down the road. Inquiries regarding the contentious Howey test are currently underway by the competent authorities. Stuart Alderoty, Chief Legal Officer of Ripple, examined the elements of a cryptocurrency ecosystem mentioned in a March 27 court decision. A statement that was just released to the public made this evaluation public. Coinbase was also a party to Judge Catherine Fia's decision, which is an interesting aside. The term ecosystem was used to describe the coordinated activities of 13 separate crypto assets issuers and promoters. In order to provide a description of the ecology, this was done. As the latest move by Coinbase shows, there are 4 different schools of thought on the topic of cryptocurrency ecosystems. The ruling has these views. It is precisely this difference that establishes their status as securities under federal policy. In response to this plan, Alderoty voiced her disapproval, claiming that the Securities and Exchange Commission SE artificially complicates the idea. Regardless of the motivation for the purchase, he believes that purchasing a token is equivalent to investing in an ecosystem. Even if this is the case, the Bitcoin community is nevertheless quite interested in a recent court ruling about Coinbase's SE issue. Coinbase moved to dismiss the financial allegations, and on March 27th, Judge Catherine Furr partially approved the motion. However, it was not thought that the accusations leveled against the business were totally unimportant. In particular, when considering the Sex's Bitcoin Foundation before the SEC appeals the decision on the programmatic sales of XRP, a precedent-setting ruling in favor of Coinbase could be reached by the judge. If the judge rules in favor of Coinbase, this scenario would play out. Concerns have been raised regarding MTD by the state of Kentucky. John A. Dion, an attorney, had the belief that Monday the SEC might be able to solve the Ripple situation. The chief legal officer of Ripple, Stuart Alderoty, provided some perspective on the most recent ruling that was given out on March 27th in a statement that she issued. It was Alderoty who brought to light the problems caused by the Coinbase decision, which defined a cryptocurrency ecosystem in 4 different and confusing ways. In his ruling, Judge Fila found that the SEC applies a narrower interpretation of the term ecosystem in this particular issue. The matter was concluded with the delivery of this decision. This expression alludes to the businesses that are being considered by the people behind the 13 digital assets that are presently under investigation. The court also employs an interpretation of the term similar to the one stated above when deciding whether transactions involving these crypto assets meet the criteria of federal securities law. Insofar as Alderoty is concerned, your assessment is somewhat accurate if you take this to mean legalese. Investment in a dynamic ecosystem is essentially what buying a token is, according to the Securities and Exchange Commission. This is accurate irrespective of the setting or procedure used to complete the transaction. To summarize, the following is the conclusion. As soon as the judge's ruling was over, Alderoty mentioned the verdict about the XRP programmatic sales. While Torres was looking into the Ripple issue, she found out that the SEC had changed their story from the original. Someone with experience in the financial sector is Torres. This was the exact situation that Torres could pinpoint. A promoter had given investors clear promises about a specific business venture in that case. Coinbase and Ripple have not set a legal precedent on the subject of investment contracts or the proper interpretation of the Howey test. The courts will have to decide how to move forward with these cases. As of right now, the legislation does not provide any guidance to cryptocurrency exchanges on how to conduct secondary market sales of cryptocurrencies outside from investment contracts. Because the law does not yet establish any precedent, this is the situation. She maintained her stance throughout her conclusion about programmatic sales that buyers had a hard time knowing where their money was going due to Ripple's lack of transparency in transactions. Until the very last, she clung to this opinion. Throughout her decision, Judge Annalisa Torres made this statement. In 2017, programmatic sales of XRP by Ripple made up less than 1% of the total XRP trading volume globally. In 2017, this was the situation. Given this, it's safe to assume that most people who purchased XRP on cryptocurrency exchanges weren't planning to invest in Ripple. The decision cannot be used as a precedent for any future Bitcoin cases, especially the one involving Coinbase, according to Judge Torres. This severely restricts the ability to set a precedent. A major case relevant to the matter is the Securities and Exchange Commission (SEC) in the context of digital assets in the U.S. and the cryptocurrency market globally. The general lack of a regulatory framework and legal precedent for cryptocurrencies in the U.S. bodes poorly for XRP's market performance. The reason XRP is expected to encounter challenges is because of this. You shouldn't use the given information as trading advice, and we won't be held liable for any investments that might be based on it.